The first category is people arguing that the exclusionary rule, people who watch police drama know that on CSI and several others, if you get the evidence illegally, you can't use it in court for a criminal conviction. So the gentleman in this first case argued that the Fourth Amendment search and seizure exclusionary rule applied in his discipline hearing, and that any evidence uncovered in an unconstitutional search would not be admissible in an administrative hearing. Now, fortunately, the court found that he was wrong and pointed out that the exclusionary rule is very rarely applied to discipline, but it gave some nice standards of what you have to be careful to make sure that the exclusionary rule never takes away the evidence that you have. Once this employee saw that criminal charges were dropped because the search was illegal and violated the Constitution, he argued that the same thing should apply to his discipline case. And that's when the court came up and said, no, for many years we've had two standards at least. You have to have a tight nexus. The people who do the search have to benefit from the illegal search. So for example, if your city and your police department does the search, and you're the one presenting the evidence and you'll benefit in terminating somebody because of the evidence, you're going to have a harder time using the arguments they did here because there might be a real nexus. The department might be tightly enough connected to you. You've got to keep that wall in between to make sure that nexus isn't there. And then there's a balancing test, and the balancing test is the rights of the person on the search and seizure and the rights of the public, the social consequences. And the court points out in criminal law, where criminal penalties are designed to punish the criminal. So therefore, excluding the evidence so that the person who violated the law doesn't get punished is a fair way to do it. But in administrative penalties, yeah, they're punishment, but mostly administrative penalties are designed to protect the public. You dismiss a bad teacher to protect the students. You dismiss a guy carrying a 9mm handgun in his work truck because you're worried he's going to kill somebody in the public. And in that balancing test, the courts asked, was the evidence obtained under circumstances that shocked the conscience? And of course they said no. Remember that the Spielbauer Santa Clara County case, the Court of Appeal had said that before you could give an employee a Liebarger direction, either answer, we won't use any information you give us for a criminal complaint, and you have to answer us or we'll dismiss you for insubordination. The Court of Appeal had said that that was not proper, that first you had to go to court and get a formal grant of immunity before requiring the worker to answer any questions about their job performance. Of course, everybody saw this and all the news releases and everything else. The Supreme Court said that's not true. An agency need not obtain a formal grant of immunity from the district attorney's office before requiring a worker to answer questions, as long as you're not requiring that worker to waive their constitutional rights against self-incrimination. And you can solve that by telling them that you're not going to give any of the information from your interviews to the people doing the criminal investigation. I do want to remind everybody that the California professional firefighters were extremely successful in the last couple of years. Remember when they passed Firefighter Bill of Rights? And in the Firefighter Bill of Rights, it's actually Government Code Section 3253E. There is the wording was included from the Court of Appeals Spielbauer decision that requires you to obtain a formal grant of immunity before you give a Liebarger warning to a firefighter and question the firefighter. Firefighters, by the way, have won a number of interesting little things that you have to watch out for. It's not on my list to talk about, but just in the last 2 weeks, a Court of Appeal decision was issued, City of San Jose and their firefighter union, where the same California professional firefighters attorney that wrote Firefighter Bill of Rights had also written some legislation that passed that said basically that any dispute about what the scope of bargaining, when you have an interest arbitration provision in your charter, and the interest arbitration is with firefighters and only firefighters, has to go to Superior Court and not to PERS. Where you apply for somebody to be retired for a disability under PERS or STRS or one of the university retirement systems. And when you do that, you really haven't terminated them, but they get a hearing from the administrative law judge of whether or not they're truly disabled under PERS. Anytime you terminate somebody who's a peace officer, it's punitive. And under the Police Officers' Bill of Rights, you've got to give them the hearing before you take punitive action. Terminating somebody because you allege they have mental problems is still punitive. They're gone, they have no job. You're applying and saying they're disabled and they're getting disability retirement. But the theory behind that is that they don't stay retired forever. They're supposed to get healthy and come back to work and keep working. Now, STRS has a whole division of people that goes out and interviews the teachers who are on disability and keeps checking to make sure whether they could come back to work so they would get off the rolls and not spend the money. I don't know how much all the retirement plans do that. But the theory is, and the court goes through it again, that when you're on disability retirement, you still have a cord to the employer. There's a relationship there, an employment relationship. But when you terminate somebody, they're terminated. And that's why they would have to have done the MOU hearing to give her due process before they terminated her. You can't say that the level of hearing you get for PERS retirement is enough due process to cover a termination decision. The second element of the case is all about disability accommodation under state law, and the case has been sent back to a lower level to have more legal work done on it. And I'm hoping that it will turn out, it can be presented that what the county was doing was not forcing him out and taking away his pay, but based on the doctor's notes he was bringing in, they were accommodating him. They were not compelling him to leave. They were accommodating him and helping him deal with his depression. But the bad part about the case, the court said that the county had a policy about putting people on administrative leave and paying them while they were investigating things, and that because the county did this under color of law, they had violated the federal 1983 standards. Under color of law, they had taken away his property rights. And I'm worried about this, because don't all agencies have some form of paid administrative leave while you're working out a problem? You're arguing about what happens next. Are they waiting for tests? Are they waiting for an investigation? So this one really worries me, and I'm hoping that as the case continues, now that it's been sent back, that the argument will get focused on this was a reasonable accommodation and not a due process case. It shouldn't have been handled as a due process case. The court made a mistake, because this was a man with depression. He had to be out for sinus surgery, he had broken ankles, he had difficulty making decisions. It sounds like there's enough there that he could have been reasonably accommodated, and I hope that will get rid of that paid administrative leave.